If you know your microphones are not muted, I just ask that you keep a quiet background as we are about to begin the presentation. Thank you. All right, so let us begin. Welcome everybody. This is our second session for today. We had one session in the morning from 9 to 11, and now we're having another session from 5 to 7. I know it's been a long day for many of you. You're here after work. So many of you, your brains are tired, everybody's tired, but we ask you to bear with us. We're going to provide you with what we think is a wealth of information. So we hope you just bear with us and give us your attention. Give us any comments you may have, pose your queries to us, and we will do our best to answer you. So this is a presentation on the Companies Amendment Act 2023. It's brought to you by the Companies Office of Jamaica. My name is Amanda Wallace. I'm legal officer at the Companies Office of Jamaica, and I will be presenting the first part of the presentation. So I will be your presenter for the first, maybe about 40 to 60 minutes of the presentation. After that, I will pass on the microphone to Mrs. Bennett. Many of you are probably familiar with Mrs. Bennett. She is our AML/CFT manager. She's a manager of that department. Her full name is Mrs. Inger Hainsley Bennett, and she will be doing the latter half of the presentation. Gentle reminder, because I do hear some shuffling in the background, for you to mute your microphone, and also for those who are unable to mute their microphone, if you could just keep a quiet background for now until our PR officer is able to mute you when he gets hosting rights. Continuing, joining us this evening is also our Acting Chief Executive Officer and Registrar, Ms. Shelley Leon. She would have introduced herself at the beginning of the session at 5 o'clock. However, for those of you who joined a little bit past the hour, I will reintroduce her. She is joining us for this evening's sessions as well. At the end of the presentation, Mrs. Bennett, myself, and Ms. Leon will be available for questions. We ask that you hold all questions and comments until the very end. We know we're introducing changes to the Act, so as we introduce them to you, you may have questions, you may want to ask them right away, but we ask for the sake of efficient presentation, time-efficient presentation, that is, that you save all questions till the very end, all questions and comments, that is, until the very end. All right, so without further ado, I will jump right into it. All right, so a flow of the presentation. Now, this content, this table of content is by no means exhaustive, right? It's just showing the general points that we will be touching on throughout this presentation. We'll start off with a brief introduction as to how these amendments came about, why were they passed, the background behind all of that. Then we'll go into some important definitions that the Act mentions. We won't be able to go into every single definition in the Act, but we'll certainly mention the main definitions that we think it's important to bring to your attention. From there, we will go into the privacy of the information, that is privacy of the beneficial ownership information. We will then have a look at obligations. From there, we will go on to tell you when to file the beneficial ownership return, because there is a beneficial ownership return which will be filed at different periods in time. Sorry, different periods in time, sorry. So we will go into that. We will also be looking at prohibitions. So what is prohibited under this Act? From there, we look at COJ's powers overall. So what are the new powers that we received as a result of the Amendment Act? From there, we'll go into sanctions. Then we'll look at the new forms, and then we'll have a look at next steps for existing companies. Now, we understand that there is a time constraint, right? We're going to try to bring this information across to you in 2 hours. However, we anticipate that that may not be possible. So in the event we do run out of time, we will be isolating important topics just to bring to your attention. And then in part 2 of the session.
Mr. Mary James.
Sorry, somebody has their microphone on. Once again, I cannot emphasize this enough. I know I sound like a broken record, but I ask you all to pay attention to your microphones, right? Try not to turn them on throughout the session. It will disrupt the flow of the presentation and affect how long it takes us to complete. So please keep your microphones off and video off, all right? So as I was saying, for the sake of time, we are aiming to complete all these topics within the 2 hours. However, if it is that we are running out of time, we will try to focus more on the more pressing topics. And as we go on, we'll let you know what those are. Mrs. Bennett, who will do the latter half of the presentation, will indicate to you what she will be covering. And fret not, for those topics that we did not cover today, we will definitely be covering them tomorrow, right? So do not worry. So let us begin. Introduction. So as most of you are aware, the Companies Act was amended in 2017 to require companies limited by shares to provide beneficial ownership information, right? And that was the first time that the COJ really rolled out the beneficial ownership regime. However, the Financial Action Task Force determined that our regime, or beneficial ownership regime, was lacking and it wasn't adequate, right? So what the Companies Office had to do, and of course, by extension, our local and international stakeholders worked with us, we had to actually revise our BO regime and have a look at the amendments that were passed in 2017 to see how we could make them more extensive and adequate in order to meet international standards set by the FATF. So this Amendment Act is a product of that, right? It is a product of that project that was embarked upon by the COJ and other stakeholders to revise the Companies Act to make it more, extensive in the BO regime aspect at least. So this is a product of that. And in passing this act, we are hoping that it will ensure greater transparency in corporate governance, and greater transparency should reduce the risk of legal persons, specifically companies, being abused and used for money laundering and terrorism financing, right? We want to reduce the risk of companies being used for financial crimes. So that is just a little bit of a background. You will see highlighted here to the right, recommendation 24 from the FATF guidelines. We encourage you all, for your own personal reading and research, you could go ahead and look at this recommendation. Once again, implore you all to turn off your microphones. Hearing a little bit of noise in the back. So just imploring you all to turn off your microphones. Continuing, we would recommend that you have a look at the FATF guidelines, specifically recommendation 20.
You're muted.
Right, I apologize about that. Right, thank you. Yes, I apologize about that. I think I was muted accidentally, but I'm back on now. Sorry. Let me go back. Having a little bit of technical difficulties here. Right. So I hope you're all hearing me clearly now. I think you should be. Is everyone hearing me now?
Yes, hearing you now, hearing you.
Perfect, all right. So continuing, we would recommend, just for your own personal reading and research, for you to familiarize yourself with the FATF guidelines, specifically recommendation 24, because that is a recommendation that actually guided the formulation and the creation of these amendments. So we would encourage you, for your own personal reading, just to have a look at it. Moving along to the definition section. So as I would have mentioned before, we will not be going through every single definition in the Amendment Act, right? We'll just be highlighting a few that we think are very important for you to note. So the main one, beneficial owner. And as I mentioned this morning in our earlier presentation, for those of you who have been following our sessions, we've been doing training sessions over the past 2 years on beneficial ownership. And if you have been following our training sessions, you would appreciate a little bit of a difference in the definition of beneficial owner here and the one that we were presenting to you in the past. And at this point, I just want to mention that we have added a third limb to the definition, a fourth limb to the definition. Previously, it was 3. In the current act as it is passed now, there are 4. So I just wanted to highlight that just in case some of you may notice that was something in revising and reviewing the draft that we decided was integral to add. So let us begin. So a beneficial owner means the individual who exercises, whether directly or indirectly, ultimate effective control and ultimate ownership of a company. So they exercise both these powers simultaneously, ultimate effective control and ultimate ownership of a company. 2, if there is no one exercising both ultimate effective control and ultimate ownership at the same time, then the company would identify the individual who exercises, whether directly or indirectly, ultimate ownership or ultimate effective control, right? So the first limb is that it must be ultimate effective control and ultimate ownership. The second is either or, right? So either ultimate ownership or ultimate effective control. The third states the individual who exercises control or ownership in any of the ways stated in paragraph A or B over a company, body of persons, trust, or other legal arrangement, who in turn owns 25% or more of a company. So this really speaks to the whole notion of a chain of ownership. So if you have where you have a corporate member in the company, it would be the beneficial owner of that corporate member. If that corporate member is owned by a chain of companies, it would be the beneficial owner of the last legal entity, the last legal person in that chain of ownership, right? But we'll get into that later on when we're looking at direct and indirect ownership. For now, just keep in mind that this is one of the ways in which a beneficial owner can be defined. Fourthly and lastly, in the absence of an individual referred to in A and B, it would be an officer of the company who exercises ultimate effective control of the management of the company. And I don't want the word officer to mislead you. We know the term officer has a legal definition in the Act to mean director or company secretary. In this particular context, it is not referring to only those persons, right? It is just stating that anyone with ultimate effective control of the management of the company can be named as beneficial owner, where no one can be identified under the first or second limb, right? So those are the 4 ways in which a beneficial owner can be defined. Ultimate effective control versus ultimate ownership. So in the definition stated a little while ago, I would have mentioned both these terms, and it's important to look at what they mean under the Act, right? Ultimate effective control means a control exercised by an individual through means or mechanisms other than by direct control, and that person is in a position to determine the company's policy or to make the final determination as to the decisions made by the company. Ultimate ownership, on the other hand, means any circumstance in which the ownership of the company by an individual is exercised indirectly through a chain of ownership, through companies, corporations, or any other mechanisms, or himself or jointly with another, right? So pretty clear, both definitions. Accurate, adequate, and up-to-date. Now, you will hear these terms a lot, and in implementing the amendments to the Act, you will also, I'm sure, hear these terms a lot from representatives from the COJ when we're indicating the standard for the information that we are collecting, right? So these terms represent really the new standard for beneficial ownership information. No longer will we just be collecting the information and accepting it as is. We're now requiring that the information be accurate, adequate, and up to date. So it is important for you to have an understanding of what these terms mean, since you are the ones, as customers or companies, you are the ones who will be preparing the documents to submit to us with the beneficial ownership information. So you must appreciate that the information contained therein must be accurate, adequate, and up to date. So accurate. In relation to information on beneficial ownership, means correct in all details, exact, and without mistakes, right? Adequate, in relation to BO information, means information that is sufficient to identify the individual who is the beneficial owner and the means and mechanisms by or through which that individual acquired beneficial ownership. Up to date, in relation to information, beneficial ownership information, means current in all details and updated within 14 days after any communication or occurrence of any event which renders the information inaccurate or outdated, right? Pretty clear and straightforward. So those are the important terms that we wanted to bring to your attention. There are one or two other terms that will be defined. Sorry, someone's mic is on. There are other terms that will be defined throughout the presentation, and they have been defined at that point in time because of how they relate to the material being presented. So you can keep an eye out for those terms. At the moment, we're going to move on to privacy of beneficial ownership information. And as you can appreciate, beneficial ownership information will be kept private, right? It would not be available for the public to view it. And just using a very basic example, in the way in which you're able to search the website now, search it for information on the company, basic details on the company, or you're able to search records, that is documents filed by the company, you will not be able to do that with beneficial ownership information, right? It will be held privately. However, the Act does allow an avenue in which persons can follow in order to make a request to the registrar, that is the COJ, to view beneficial ownership information, because there may be times that arise where ordinary members of the public may need to view beneficial ownership information. And if that does arise, the Act stipulates that you must put that in writing. You must put that request in writing, outlining your reasons for making such a request. And you must attach a copy of the consent from the beneficial owner, right? So two things: requests must be in writing, outlining why you need to view the information and that you need to view it. And you must also attach the written consent to this, the written consent of the beneficial owner to the COJ, right? It is important that both these documents come in at the same time when making the request. Other entities may also be able to view beneficial ownership information. However, they do not need the permission of the beneficial owner in order to view beneficial ownership information. The Act allows specific and certain entities or authorities, I should say, to view beneficial ownership information in order to carry out whatever mandate they have, right? And before I state how the registrar should facilitate these specific authorities, I should probably tell you who those authorities are. And it is shown here on the screen. These authorities are A, competent authorities, B, an authority of a foreign state or country that has functions similar to that of a local competent authority, C, the designated authority, D, a constable not below the rank of sergeant, E, the commissioner of customs, F, the commissioner general, and lastly, G, the director of public prosecutions, right? So those are the authorities that will have access to beneficial ownership information, still have to put in a written request, but they do not need the consent of the beneficial owner. So when they put in this request, the COJ should facilitate the viewing of the information by these authorities. So in facilitating their request, the COJ must permit an officer of the authority to inspect the beneficial ownership information. That is pretty straightforward. The COJ must also provide them with certified copies of any document they request. So if upon viewing the beneficial ownership information, they decide, well, we would require a copy of a certain piece of document, whether it is, for example, the identification document, etc., then the COJ is under an obligation to facilitate such a request. And lastly, we would have to furnish the authority with any additional information that they may require, right? And this additional information may be other documents on the company's record that they may not have seen or been able to view by looking at just the beneficial ownership information. So perhaps they want to also view the return of allotment that is connected to the commencement date of such a beneficial owner. Then the COJ is under an obligation to facilitate this request as well. Right? So that is just an example. And these are really the three ways under the Act that the COJ should facilitate a request from an authority to view beneficial ownership information. So given that beneficial ownership information is private, how does this affect the services offered at customer service, right? So firstly, beneficial ownership information will not be provided in a status letter. So currently, many of you're used to coming to the company's office, putting in a request for a status letter, and on that status letter, you would get information, current information about the company's records at the COJ. That will not happen with beneficial ownership information. In order to obtain any sort of beneficial ownership information, the company will be required to go through the procedure I mentioned before. Any request for beneficial ownership information must be directed to the AML/CFT unit, right? You would have heard me at the introduction say that Mrs. Inga Hainsley Bennett is the manager of the AML/CFT unit. It is that unit that you will be directing your requests for beneficial ownership information to, right? Lastly, beneficial ownership information cannot be provided over the phone or in an email. I know many of you as frequent customers to the company's office, you have built a relationship with many of our staff members here. And so you're used to just calling us up over the phone or in an email or through text even to say, hey, listen, can you provide me with some information and so company or so director? In the case of a beneficial owner, we are not able to facilitate those requests, right? If you need information on beneficial owners, you cannot do it over the phone, in a text, or in an email. It must be through the procedure I just outlined. So how do we identify a beneficial owner? The Act also speaks to this, right? So the Act states clearly that a beneficial owner shall be identified through either direct means or indirect means. So let us have a look at what both these terms mean, starting with direct beneficial ownership. So the beneficial owner of a company may arise directly through ultimate ownership or ultimate effective control in the following ways. And this is the first way. So where the member is a body corporate, right? Where you have a corporate shareholder or corporate member, then it would be the individual in that corporate shareholder or corporate member that has 25% or more shares, the individual that has 25% or more voting rights, the individual having the right to exercise or actually exercising dominant control over the body corporate, or the individual having the right to exercise or actually exercising dominant influence on the policy of the body corporate. Another way that a beneficial owner can arise through directly, I should say, through ultimate ownership or ultimate effective control is in the case of a chain of ownership. It would be the individual who owns or has voting rights, has the right to dominant control or dominant influence, or who exercises dominant control or influence in a manner specified. And these are paragraphs. It's referring to paragraph Roman numeral 1, 2, 3, and 4 in the Act, right? I believe this would be 377Z, A, Roman numeral Roman numeral 1, 2, 3, and 4 in the Act. In the last body corporate in the chain of ownership, where the first body corporate in the chain of ownership owns 25% or more shares in the company, or 25% or more of the total voting rights. And this is very similar to what I would have mentioned in the definition, where you have several different companies in an ownership, in a ownership structure, in a chain of ownership. Then the beneficial owner would arise, and you would look for the beneficial owner in the last one in that chain of ownership. So the first one would be the one that actually owns shares in the company. That would be the corporate shareholder or the corporate member. And then you would start there, that would be the first, and then you would go to the last body corporate in that chain of ownership to identify who is the beneficial owner of that company. Next, in the case of a chain of ownership, it would be the individual who owns 25% or more shares in aggregate of the shares owned in each body corporate in the chain of ownership of the company, or has 25% or more of the voting rights in aggregate of the percentage of voting rights held in each body corporate in the chain of ownership directly below the position of the company in the chain of ownership. I believe this is the last point on direct beneficial ownership. It would be the individual who, pursuant to a nominee arrangement, owns 25% or more shares of the shares in the company, or has 25% or more of the total voting rights of all members having the right to vote in the company. All right, so indirect beneficial ownership, right? So the first way in which you will you can identify a beneficial owner indirectly through ultimate ownership or ultimate effective control is where the individual not being a member or an officer of the company, so they're not in the company at all in any of these capacities, but they have the ability to still appoint or remove a director. They have the ability to exercise significant influence, or they're actually doing so. That is exercising significant influence on the policy of the company, or they have the ability to exercise significant control over, or actually exercises significant control over the affairs of the company. Then it would be indirect beneficial ownership. And you would appreciate why this is indirect, because they do not exist. They do not exist in the company in a formal capacity. They're not a part of the company as a member or officer, but still they're able to exercise great influence over the company. So in such a way, we call it indirect, because it's not direct, because they do not have a position in the company. All right, still on indirect, the individual that has the right to exercise or actually exercises dominant influence on the policy of the company through means other than ownership interests in each of the bodies corporate in the chain of ownership of the company, where each body corporate in the chain of ownership has ownership in the body corporate immediately preceding it in the chain of ownership, or has the right to exercise or actually exercises dominant control over the affairs of the company through means other than ownership interest in each of the bodies corporate in the chain of ownership of the company, where each body corporate in the chain of ownership has ownership in the body corporate immediately preceding it in the chain of ownership. A lot of chain of ownership, I know that term is being repeated constantly, but it is because we appreciate that a lot of companies, their ownership structure can be very complex. And so it is not as simple as just John Brown, Mary Jane, and David Smith being shareholders. A lot of companies have complex ownership structures with several different body corporates in the chain of ownership. So the Act is trying to provide for those specific scenarios, right, where they may arise. Obligations. All right, so at this point in time, we'll be moving on to obligations that companies will now have under the Act. And this is a very broad heading. I know many of you are really anticipating this particular section because this is a section that will tell you what you have to do now that the Act is passed, right? So it's all good and well to know how to identify the beneficial owner, and good and well to know what a beneficial owner is or who a beneficial owner is, but now you need to appreciate what do you have to do now that the Act is passed. So let's have a look at your obligations, and we'll be starting with local companies, right? So the first obligation that we see here is to keep membership and beneficial ownership information in the register of members. Right, so if you weren't doing it before, now you definitely have to. You definitely have to keep membership and beneficial ownership information in your register of members. 2, there is the obligation to obtain beneficial ownership and membership information before entering an allottee as a member in the register of members. And what this means is that, very quickly, it's straightforward, but what it really means is that where shares are allotted to an individual or to a legal person, but let us use an individual for the sake of this example, where shares are allotted to such an individual, you cannot or you should not automatically enter that person in the register of members, right? Before entering them in the register of members, the company has to ensure they have all the particulars of the person and of the beneficial owner before they can enter them into the register of members. So it makes no sense to enter them into the register of members and you don't know what their occupation is, what their date of birth is, you have no ID for them. No, the Act requires you to collect all those pieces of information prior to entering them as an allottee, or sorry, as a member in the register of members or as a beneficial owner in the register of members. Moving on. Obligation to notify the COJ of the location of the register of members. And that is really just for practical purposes, right? The COJ needs to be aware of where your register of members is kept, because in the event of an investigation or inspection, we need to know where to go to inspect and to investigate. So we have to have notice of your location of the register of members. Next, the company is also under an obligation to notify the registrar of any change in the location of the register of members. So if your register of members was at 2 Love Lane Avenue, but because the business relocated, it is now at 3 Orange Street, you have to notify the registrar about such a change, all right? Next, you have changes to information kept in the register of members, right? So you have to notify the registrar about changes to the particulars of members, changes to the particulars of beneficial owners, and you have to notify us about this within 14 days, right? So you don't get to do it whenever you're ready. It must be within 14 days from the date of the change. And like with any other general rule, there is an exception to this. Public companies and companies limited by guarantee without share capital are exempted from notifying the registrar about changes in membership information. And you can appreciate why. Companies limited by guarantee and public companies, as most of you are aware, have hundreds of members. In the case of companies limited by guarantee, they would be associations, clubs, etc. So they would have several different members. Same within the case of a public company. So it would be an administrative nightmare, right? For companies to constantly notify us about these changes in particulars of their hundreds of members. And it would be very onerous too on the companies, right? That's just a very practical way of looking at things, right? It would be very onerous on companies to do that, and it would be very administratively difficult for the COJ to monitor all of those coming in. So we have provided an exemption in that way. But make no mistake, public companies and companies limited by guarantee are without share capital are still required to file changes in beneficial ownership information. So you don't have to tell us about the changes in membership, but you definitely have to tell us about changes in the beneficial ownership information. Moving on, there's obligation of on companies with 50 plus members to keep an index of members and beneficial owners. And this is just for proper record keeping, right? You keep an index of all the members and all the beneficial owners. Moving along, obligation on all former and current officers, employees, auditors, and agents of the company to permit the COJ's access to the property to carry out an inspection or examination. Now, you would have heard me mention before in this presentation that the COJ received new powers. Those powers are powers of inspection and powers of investigation and examination. Now, the employees, etc., officers, employees, etc., when the COJ comes to your premises to carry out this investigation, to carry out this inspection, you are under an obligation as an employee or officer, etc., of the company to facilitate and allow this inspection. One moment, please. I'm so sorry about that. Sometimes speaking for long periods of time, I do have to take a little break to drink some water. So I apologize for that, but continuing. So these persons have to allow the COJ access to the property to carry out the inspection and to carry out the investigation. They're under an obligation under the Act to do so. And Mrs. Bennett, who will be presenting in the latter half of the presentation, will be going into more detail about the COJ's powers, if time provides at least. So continuing, obligation on the company to record measures and methods used for verifying beneficial ownership information and to record substantiating documents used to verify same. So the registrar is not the only one under an obligation to verify beneficial ownership information. The company must also verify the information that they're collecting from these beneficial owners. And not only must they make note of the documents used to verify, but they must record the measures and methods that they employed to carry out such verification procedures, right? And this is important because if the company is investigated or inspected by the COJ, then these are the things that we will be looking for to ensure that you are compliant with your duties and your new obligations under the Act. Continuing, obligation on all former and current officers, employees, auditors, and agents of the company to give the COJ documents relating to the register of members and or beneficial ownership. So once again, if you are investigated by the COJ or the COJ visits your premises to inspect documents and the COJ makes a request for documents relating to the register of members and or beneficial ownership, you are under an obligation, you referring to the company and by extension, the company's officers, employees, etc., to provide the COJ with these documents. Next, obligation on companies to enter the particulars of beneficial owners where the company receives any notice of trust, whether express, implied, resulting, or constructive, that affects the membership of the company. Continuing, a lot of obligations. I know we did say that it was a wealth of information. So continuing, obligation to notify the COJ of any changes to beneficial ownership information within 14 days from the date the change occurs. We would have mentioned that before. Obligation to rectify any inaccurate, inadequate, or out of date information when you receive a notice indicating same from the COJ after an inspection. So when we come to the business premises and we would inspect your documents, investigate or investigations, we would identify, if any, certain inaccuracies, if there's inadequate information, or if the information is outdated. And when we do identify that, we will give you notice for you to change it. And you are under an obligation under this act, the Companies Act, to comply and to rectify same. Next, obligation to answer any question posed by the COJ regarding its beneficial ownership information in writing and in the manner and time frame specified by the COJ. So it's reasonable to assume, right, that when an investigation or inspection occurs, the COJ representatives may have questions for the company and by extension its officers and employees. These persons are obligated per the Act to respond within the time and in the manner that the COJ specifies, right? Next is the obligation for companies to keep beneficial ownership information and relating documents for 7 years after, or at least a period for at least 7 years after the company is wound up or struck off, right? So after the company is dissolved, the company is under an obligation. And yes, I know it sounds silly to say, because if the company is dissolved, then one would say it no longer exists. But after the company is dissolved, it still has obligations, right? It is under an obligation to keep beneficial ownership information and relating documents for a period no less than 7 years. All right, so overseas companies, there are a few obligations, not many, that apply specifically to overseas companies. And these are the obligation to keep a register of directors in addition to the register of, the register of directors in addition to the register of members. Then there is obligation for overseas companies. It's now mandatory for overseas companies to provide beneficial ownership information, as the word any has been deleted from the Act. So overseas companies can no longer say, well, we did our searches and our checks and we can't find a beneficial owner, or beneficial owner doesn't exist in our jurisdiction, so therefore we have none to provide. No excuse will be accepted. So either you provide the beneficial ownership information or you can't register. Right? It is mandatory. Next, overseas companies are prohibited from having and appointing nominee directors. So very similar to local companies, overseas companies are now prohibited from having and appointing nominee directors. Lastly, overseas companies are to submit a copy of their certificate of incorporation with a beneficial ownership return form. So you have heard me mention previously that there is a beneficial ownership return form that persons will be required to complete. And for overseas companies in particular, they will be required to attach a certified copy of their certificate of incorporation with their beneficial ownership return form. So this will be filed every year. So every year they file their beneficial ownership return form, they have to file a copy of their cert of incorporation with that beneficial ownership return form. So we're still under the broad heading of obligations, right? I did say it was a little bit lengthier. This is one of the lengthier sections because there are a lot of new obligations for everybody, companies, COJ, company employees and directors, beneficial owners alike. There are lots of new obligations for everybody. So we're going to look at now the specific duty or obligation of the company to obtain beneficial ownership information, right? And that is a clear and explicit duty stated in the Act that a company is under the obligation to obtain beneficial ownership information. But let us break it down a little bit, because the Act doesn't say that and leave it blank, right? It extends it a little bit more to make certain considerations. So let us go into detail into each. So the first one, the Act requires companies to notify the member and or beneficial owner of their obligation to furnish the company with beneficial ownership information. And this must be done once a year, or where the member or beneficial owner fails to notify the company. So I like to say this in a very layman terms. The company essentially has to be running down members and beneficial owners for the information. That is what it comes down to, right? Just to speak very freely, right? You have to ensure you keep up with the members and beneficial owners to ensure that they're submitting to you the particulars that they need to. So it's not enough, the obligation for you to obtain the information. You must constantly follow up with them to ensure you're getting the information you need, and that the information you need is accurate, adequate, and up to date. Next, the company is required to verify the identity of the beneficial owner and record the basis on which the individual was identified as a beneficial owner. So how do you know the person is who they say they are, right? You have to do your own checks to ensure that the person who you're submitting as beneficial owner is who they say they are. So you have to verify their identity, and you have to also record what makes this person a beneficial owner of the company. Is it ultimate ownership? Is it ultimate effective control? Is it both? Is it management? What is it? Is it through a chain of ownership of different body corporates? What is it? You have to record that. Lastly, the company is under an obligation to appoint an officer or officers who shall be responsible for verifying beneficial ownership information. And these persons will also be responsible for all the things I just mentioned before, as well as sending notices. So the Act appreciates that this is not a job that can be done lightly. So you have to actually have a designated person or persons, depending on how big the company is. Because if it's a small one-man company, we imagine not that we're making any recommendations to anybody on how they should go about exercising this obligation or this right. But if it is a small company, you can anticipate that maybe one officer, one person could carry out these different duties. That is to verify the identity, send out the notices, follow up with the members, follow up with the beneficial owner, right? Because it's a one-man company. So chances are, or even if it's just two shareholders, two members, one person could probably do the job. But in the case of larger companies, then you would have to possibly designate several persons to keep up with these duties to ensure that the company is compliant. All right, so notices. You would have heard me mention just now when I spoke about the designated persons who will be ensuring the company keeps up with these obligations, that they are under an obligation to send out notices. So what are these notices that I speak of? Let us elaborate a little bit. So the first notice that is sent out by the company gives the beneficial owner or the member 30 days to respond, right? And it is important to say at the onset here that all notices, whether it's the first, the second, or the third, all notices must indicate what information you're requiring from the beneficial owner or the member. You must state clearly that they're under an obligation to furnish information or such particulars. You can go ahead and state what the particulars are, and you must state explicitly the information that is outstanding or the information that is inaccurate, inadequate, or outdated that you need them to update. All right, that is important that you state that in the notice. So you will send out your first notice to them, right? And you will give them 30 days to respond. The second notice, if no response is received from the first notice, or the company receives a response, but the response does not rectify whatever needs to be rectified, then you will have to send out a second notice. The second notice, as the company, you give them 21 days to respond, right? Because they had 30 days at first. So let's just lessen the time now, right? You give them 21 days to respond to this second notice. Say they still don't respond or the response is insufficient, you can send out a third notice, right? Where you send out a third notice, you give them 14 days, 2 weeks to comply, right? And if they do not respond to the first, second, or third notice, and, well, I should say, or the response is insufficient or lacking and cannot rectify what needs to be rectified, then the company will have to, then the company will have to proceed to repurchasing the shares owned by the members or the beneficial owners, right? So that is the ultimate consequence from these series of notices, right? So your first, second, and third notice under Section 377X, no response from there, then the company is under an obligation to repurchase the shares. Now, the Act appreciates that you can't repurchase shares in every single scenario. So it outlines some exceptions to the repurchase of shares. First one being where there's only one shareholder, one-man company. B, the company is not in a financial position to do so. Or C, the company's articles of incorporation does not allow it. So it does not permit the company to do this. Then the company should refrain from repurchasing the shares. However, the notices must still be sent out, right? So the notices must still be sent out and the company must still keep record of the notices, and if any responses, they should keep record of that as well. So duty to update ID documents is a pretty straightforward obligation. We don't have to spend too long on it. The company is under an obligation to ensure that the ID documents for the beneficial owner and the member are up to date. They're not expired. If they are expired, then they have to obtain a certified copy of the updated one. And this copy can be certified by an attorney, consular officer, diplomatic officer, JP, notary public, officer duly authorized by law to administer oaths, or affixing an apostille. So we give you some amount of options, right? It's not very restrictive. I think these options allow you to find someone pretty easily to certify a copy of an identification document. And of course, touching a little bit on the forms, even though Mrs. Bennett will go into this, a notice of this must be given to the COJ on the form 5A, right? But Mrs. Bennett will go into that. Duty of the members and beneficial owners. So the company is not the only one with obligations and duties under the Amendments Act. Members and beneficial owners also have a duty under the Amendments Act. And let's start with the members. So for members with 25% or more shares in the company, they have to notify the company about the beneficial owner of their interest, and they have to notify the company, of course, about their own particulars. And they should do this at the time of incorporation as well as at the time of allotment. For beneficial owners, they are required to notify the company of their particulars as well, the nature of their relationship to the company. So is it that they are a beneficial owner through ultimate ownership, ultimate effective control, management of the company? They are required to notify the company of the nature of their relationship, and they must notify the company about changes to their particulars. So if their address changes, their occupation changes, their name changes because, say somebody gets married and their last name changes, that's just an example of things that the beneficial owner would have to notify the company about, and the company in turn would notify the COJ about. So obligation on everybody, right? When to file the beneficial ownership return. So the beneficial ownership return will primarily be filed primarily be filed 4 times. At incorporation, that's when you're submitting your registration or incorporation documents. At allotment of shares, when you're submitting your Form 9. Annually, and when we say annually, it could be in the case of a local company with your annual returns, or in the case of an overseas company annually, with your financial statements, or where there is a change. So where there is a change in the beneficial ownership information, you're required to file a beneficial ownership return, notifying the COJ of the changes that occurred. So what is the return date? The beneficial ownership return form, as we just established, will have a date. And what is that date? The Act provides for that as well. And the date the Act states is the return date is, in the case of a company incorporated under the Act, the anniversary of the company's incorporation. In the case of a company incorporated outside of Jamaica, that is an overseas company, the anniversary of the establishment of the company's place of business in Jamaica. Or in the alternative, in the company, if the company's last return delivered to the registrar was made up to a different date, the anniversary of that date. So required particulars for a beneficial owner and member, looking at it from a perspective of an individual, right? So we would need the individual's name, occupation, nationality, address, date of birth, tax registration number. We appreciate that not everybody will have a tax registration number. And so the Act provides alternatives, right? Could be their tax ID number, other tax ID number, could be the driver's license number, or it could be the passport number, right? You could provide any one of those to us. In the case of a member, I'm asking you to disregard beneficial owner in the title there. In the case of a corporate member, it would be the name, nationality, country of establishment, date of establishment, address, or tax registration number of the company. If it is a foreign company, so it may not have a TRN, then that foreign company must provide us with the tax ID number attached to it or associated with it, right? I think most jurisdictions would assign a tax number to companies, so they would have to provide us with that tax number, tax ID number, I should say. So this is looking a little bit at sanctions, and we do have a whole section of this presentation dedicated to sanctions. But since we're on the topic of beneficial ownership return, we'll just mention this at this particular point in time. There is a sanction for failure to file a beneficial ownership return when you're supposed to, or where you filed one, but it contains inaccurate, inadequate, or outdated information, and you fail to rectify the information or to correct the information. So the sanction is this. The COJ will issue a first notice to the company indicating that a beneficial ownership return was not filed, or it has been filed, but it contains inaccurate, inadequate, or outdated information, right? And where we issue that notice to you, we will give you 30 days to comply, right? If you still have not complied, we will issue to you a second notice, and that second notice will give you 60 days to respond. So we're giving you a little bit of time here to respond. Failure to respond to the first notice or the second or final notice, because it will be the final notice, will result in the company being struck from the register, right? So it is important that you respond to the notices within the time that you're supposed to, right? In the case of companies regulated by the BOJ and the FSC, we will consult with the BOJ and FSC before proceeding to striking off, but they are still susceptible to being struck off as well. It's just that the registrar has to consult with the BOJ or the FSC before striking them off. Prohibitions. All right, so there are certain prohibitions that weren't there before that have been introduced through this Amendment Act. First one being no nominee shareholders, no share warrants, no nominee directors, right? And also, in the case of a company failing to file a beneficial ownership return, or filed one, but the information is inaccurate, inadequate, or outdated, in such a case, the company will be prohibited from transferring shares. Well, I shouldn't say the company, but the members of the company will be prohibited from transferring shares, and the company itself will be prohibited from allowing directors to borrow money from it, right? So those are two prohibitions that will arise as a result of failure to file your beneficial ownership return, or you have filed one, but the information has not been rectified, right? Of course, if a person is aggrieved by either one of these prohibitions, they can go to court and they can obtain a court order. However, the Act does specifically say that the order is limited to allowing specific transfers or specific borrowing powers depending on what the situation may be. So it won't be a general lift of the prohibition, right? Depending on whatever your case is that you present to the court, the order must specifically provide for your particular case, not to remove the prohibition completely. So that is it for this section. So sorry. So that is it for my half of the presentation. I know it took us about an hour to go through. I was moving as quickly as possible because I know that we're all tired from a long day. But at this point, I will hand over to Mrs. Bennett. And as I mentioned before, Mrs. Bennett will indicate to you what she will be touching on given the limited time that we have. So I hand over to you now, Mrs. Bennett.
Right, thank you, Amanda. Good afternoon, everyone. Good afternoon, everyone. Thank you, Amanda. So we do have a lot of information to share with you, and we do appreciate that, well, at this hour of the afternoon, and even this morning when we did the morning group, we were not able to share all of the details. So we're going to focus for the remainder of the session, which we have just an hour left with you, because we do want to have your questions and your feedback. We are going to go straight into the forms. And so all of these changes that Ms. Wallace has carried you through, of course, I'm sure the burning question is, what does this look like when I'm filing a document at the company's office? So we're going to be looking at the forms, and I'm going to just load that presentation now. So we're looking today at the understanding the new forms that will come out of all of the amendments. Now, as the beneficial ownership information is now private, what we have had to do is to remove any reference of beneficial ownership information from the forms that they would have occurred on. And most of you would have been familiar that from 2018, we would have been requiring persons to indicate on their articles of incorporation for companies with shares and their annual returns for companies with shares, which would be the Form 1A and the Form 19A, we would have been asking you to say who the beneficial owner of the shares would have been. And so you would have been accustomed to a tick box on the 1A and a tick box on the 19A, which would have said, I am the beneficial owner of the shares, or I am not the beneficial owner of the shares. And then you would have provided us somewhere else on the form with who the person was if they weren't the beneficial owner. And of course, if the person was one and the same, that tick box of I am the beneficial owner would have sufficed, and we would have just moved right along. Now, as you can see that the amendments go much further in terms of beneficial ownership information and the requirement that the information is to be private. So all beneficial ownership information is now in a separate form and will be treated for us as a correspondence, a document that cannot be viewed to the public. And so for those of you who are very familiar with our public search stations, you will note that when you come onto that search station, you are only able to see the public part of the document. You're not able to see the filed by information. So these new beneficial ownership forms would have a similar type of status in our system where the public will not be able to view them. So all the forms, all the beneficial ownership forms will have to be submitted with the forms that used to have that information. So any form that used to make a mention of beneficial ownership information, you will now have a separate form that captures it, okay? And of course, Ms. Wallace would have explained that all companies now have to indicate who the beneficial owner of the company is. So not just the companies with shares, but also the companies without shares. So the companies that are filling out the 1B will have to indicate who the beneficial owner is, and subsequently the annual returns that come in for these companies will now have an additional set of information to provide to the company's office stating who the beneficial owner is. So just a apologies. Just a reiteration of the point that the information is now private and confidential. Ms. Wallace alluded to the fact that we'll not be providing this information in a status letter anymore, and we will not be providing the information over the phone or by email as it relates to beneficial owners. And of course, you would have explained the process of having to request the information from the beneficial ownership unit, and only persons who have the consent of the beneficial owner and have to, of course, provide us something to show that they have the consent for us to hand over that information or provide that information. And of course, entities who do not need the consent of the beneficial owner are law enforcement and competent authorities. And all of this detail is in the Amendment Act. For those of you who I know are going to be combing through to see, what this really means. Now, because the beneficial ownership information is private, confidential information now going forward, we have created a beneficial owner registry. So just as how you are able to subscribe to our website and you can go on and you can view information on companies and business names, you are going to be able to view information on beneficial owners in a beneficial owner registry. Of course, only the persons who, under the Act, will have access to beneficial ownership information will be allowed access to the registry. And so the registry was launched in January of this year. And just to give you a snapshot of what it looks like, you have our landing page or home page where you request registry access. Once you've requested access and we've reviewed your application, verify that you are one of the entities who can have access to it, then you're able to come on and do your company search. And once you've gotten to your search page, in similar fashion, you indicate the name of the company, or if you have the company's number, you type it in. And this pretty much is what your result will look like. You will see the entire information on the company, its registered address, its registration number, the date it was incorporated, and the officers of the company secretary, the director, and you will see who the beneficial owners are. And the shares, well, of course, the data that we have right now relates to only beneficial owners with shares. But as we roll out these new forms and we start capturing more information, the quality of the information that we have on beneficial owners will evolve. So for those of you who are wondering, well, where am I going to get all this information on beneficial owners? We are going through so much detail today. And of course, we do appreciate that we will not be able to cover all the content with you at this time. Now, we will be having at least 2 other sessions. There will be another session to go through the obligations again and the sanctions, because the sanction regime has also been changed. And that is something that we do want persons to understand. We will be going through the powers of the registrar because there are quite a few powers. Ms. Wallace has alluded to the fact that the AML unit, the new unit at the company's office, will be verifying information in company registers. So we'll be coming out and doing inspections and, of course, verifying the information that comes into us. So there are a lot of things and that are contained within the provisions, and we do appreciate that 2 hours cannot in any way be enough to communicate that to you. So there will be 2 other sessions, at least 2 others, one going through in detail the new forms, and a second one to go through the obligation, the sanctions, and the new powers of the registrar. But as it relates to all information related to beneficial owners, you are able to go to our new website called bohubjamaica.com. And all this information, we have a copy of the recently passed act. We have all these presentations, the ones that we're using today, as well as ones we've done in the past. You're able to see the information booklets that we have as a specific booklet on beneficial ownership information or forms, the precedents. So you're able to go to this site and access the information, all of the content, because we do appreciate that you will need to be going back to see what is the foundation material. And as you do your own research and readings, you can come here as a resource. So we're going to look at the forms coming out of all of these changes with the beneficial owner form. So we have 6 new forms that will capture the information. And the forms that are highlighted with the red text are the forms that will be private. So we're going to have a beneficial owner return form A, and that will be used for companies with shares, and a beneficial owner form B for companies without shares. We're trying to keep the nomenclature the same so persons can remember that when there's an A, it's usually a company with shares. When you're seeing a B, it's for a company without shares, as in our 1A or 1B or 19A or 19B. For the beneficial owner form C, that is for companies who will be notifying us of changes in the members, shareholders, and beneficial owners. And so C for change is also one of the easy ways to remember the form. We have 2 other forms, which is a form 27A and a form 27B. The notice of change in shareholder, member, beneficial owner. So the form 27A will have an accompaniment with the form C. And so for nonprofit companies or companies limited by guarantee without a share capital, they will be filing the 27B and notifying us of changes in their membership and beneficial owners. Of course, accept my apologies, there are no shareholders in a company without shares. So that's just a typo there. And then the last form is the form 5A. So you are familiar with our form 5, but the form 5A is for notice of change in the identification document. So Ms. Wallace alluded to the obligation for you to notify the registrar when your ID expires. So we'll be collecting a lot more information from you going forward. We're going to look at that. No, but there is no form. So when the ID has expired and you have the renewed ID, you have an obligation to file the new ID information with us. And this form will capture it. Just a reminder of the occasions when the beneficial ownership return will come in. So it will first come in at incorporation. When you're incorporating your companies, we will be getting a beneficial ownership return form. Also, when shares are being allotted, this form will accompany the Form 9 that you're accustomed to filing. It is also due annually, and our expectation is that when you're filing your annual returns, you will also just file the beneficial owner return. And of course, where there is a change to the beneficial owner information, also information on shareholders, you will have to now file the beneficial ownership return. So there are 4 occasions that you will be using these new forms. Now, just to give you a very simple overview, so we have updated our existing forms, or Form 1A, 1B, C, and D. You know, those are incorporation forms or articles. And we have updated our 19A, or 19B, and our 19E, which is our status quo, and our Form 9. Now, for these forms, you will note that the Form 1A and the 19A would have made reference to beneficial owners by that little tick box. So that tick box has been removed. And so we look at that going forward. You will note under the updated forms list is that we have Form 23. And Form 23, of course, has nothing to do with beneficial ownership information. It is our director's form, but we realize and we've taken the opportunity to reduce the bulk of that form. There are 12 pages, most of which the average person uses 3, and we've reduced it to 6 pages. So we've also added the feature for that form where all the directors who are coming on as new directors have to sign the form, okay? So the form has less pages. It's more relevant, more user-friendly, and all new directors must sign the form. So the brand new forms are our Form 31, A and B, And they're not really new in the sense that Form 31 is used for the registration of part-time companies or overseas branch companies here. And all we have done is we've split out the information. So Form 31A is for overseas companies with shares, and Form 31B is for overseas companies without shares. And we moved on to our brand new form, which is our Form 27A and our Form 27B, to note the changes in beneficial ownership information and shareholders. And the Form A, B, and C, which come with different documents. We look at the packages next. The forms in red are put in red because they are private forms or private information. And of course, the rules requiring access to the information contained on them would apply. So just for you to understand in a snapshot what is happening with the existing forms. So our incorporation forms, or 1A, we have removed all reference to beneficial owners from that form. So for those of you who have been using our forms over the years, they will look like what they used to look like, where you would just indicate at the subscriber section, who are the subscribers taking up shares on the form, and the witness signs, and moving right along, you complete your form. So all references of BO have been removed. No tick box to say I am the beneficial owner, nothing like that. However, of course, our Form 1B, C, and D, which never mention beneficial owners now, all our forms have a little notation that I have attached the beneficial owner form to my articles with the submission of my articles. For our Form 31, as I indicated just a few minutes ago, we have split it into two forms. Form 31A, overseas company with shares. Form 31B, overseas company without shares. And note, this also has a section for you to indicate that you have attached the relevant beneficial owner form. For our 19A, all references of beneficial owners have been removed from the 19A. So on the shareholder page, we usually have a little same checkbox, I am the beneficial owner. And if you indicated you are not the beneficial owner, there would have been a subsequent page for you to indicate who the beneficial owner was. That information has been removed. So the form has no reference to BO information. What you do have now on the two annual return forms, 19A and 19B, is a notation that you have included the beneficial owner return along with your submission. Our status quo returns, as you know, we did launch our status quo in 2018 when we rolled out the first set of provisions for beneficial owners. And we have now rolled out another status quo for our companies without shares. However, the use of the status quo can only occur after you have filed a new annual return, giving us all the beneficial ownership information and all the identification material as it relates to the shareholders and the beneficial owners. So we are requiring a lot more information, but we also require IDs as well. So what does that look like going forward? Now, for our file by pages, what it means is that you will have an additional file by page. You're accustomed to the usual one page for the file by. We now have, for most of our forms, two file by pages, because you are, apart from telling us the additional particulars of the directors, which would have been their names and their TRNs, their email addresses for the company secretary. And this example on the screen is for one of our articles where you would have indicated the particulars of the person who was making the declaration. You also now have the obligation to inform us of the taxpayer registration number of each subscriber and their date of birth. Usually, for the most part, at least 85% of the time, if not 90% of the time, the shareholders and the directors are one and the same person. Okay, so the information should be available and flowing. So in the instances Amanda would have mentioned where you do not have a TRN, so for overseas persons, typically you'll be familiar with just leaving the section blank for TRN. That is no longer going to be permitted. You must include the identification number. Now, if you don't have a TRN for the overseas resident or the overseas person, you have to put the passport number, the driver's license number, or any other number from an identification document. And that identification document has to be supplied along with the submission of the forms. So just to recap so that we can lay it out for you so you to see what exactly are we asking for. So right now, what we used to ask for the beneficial owner and the shareholder, we would have asked for the name, address, nationality, and occupation. The additional information, TRN, date of birth, and the relationship. How is this person deemed a beneficial owner? And of course, utilizing the definition, whether you're a beneficial owner through shares or ownership, having more than 25% of the shares, or is it through control, or is it somebody or persons who have the highest position of authority in the company? Now, additional information or uploads that we will be requiring, or correspondence that we'll be requiring, all shareholders, all shareholders, all beneficial owners must provide identification documents, whether driver's license, passport, voter's ID, or if they are from another jurisdiction, whatever identification document they may have there. The ID number and the expiry date will be recorded, so that information must be clearly visible. And all corporate shareholders and members must provide us with a certificate of incorporation. Corporate members, corporate shareholders also have an obligation to be identified under the amendments. And so for overseas companies, we will require you to provide us with your certified copy of your certificate of incorporation. Of course, local companies that are registered here at the company's office will not need to provide this, because as the registrar, we would have that information. So other body corporates who may appear as shareholders on documents or are corporate members on documents will have to provide proof of that incorporation or that registration status. So if it's an IP registered at the Department of Cooperatives and Friendly Societies and they are going to be holding shares in this company, we will need a certified copy that this company is a duly registered company, an IP. So just bringing that out to the fore, that where you have a corporate shareholder, corporate member, we will need certificates of incorporations, particularly for overseas companies and companies not registered here at the company's office. So we're going to look at what the form packages will look like. What are you going to be filing with us going forward? Because we have to separate the beneficial ownership information. Our first package is our new company package, or new company package for local companies. And as you know, the companies who are limited by shares or are always filed in our Form 1A. And this is the major company type that we get. So the companies with shares will use their Form 1A and your BRF. Those are the two documents that you're accustomed to filing. You will now be required to file the BO Form A. BO Form A goes with companies with shares. So you now have 3 documents at incorporation. Similarly, for your nonprofit companies or companies limited by guarantee without a share capital, you must file, of course, your articles of incorporation in the way of Form 1B, your BRF, and your BO Form B. So 1A, BRF, Form A, 1B, BRF, Form B. So it is now 3 documents that are mandatory for the incorporation of a company. And the BO form attracts a cost of $300, and it must be submitted with all new companies. As it relates to the new package for overseas companies, when you're registering an overseas company for the first time, you will, of course, be using the Form 31, but you'll be using the split Form 31. So for the overseas company that has shares, you'll be using the Form 31A and the BO Form A. You, of course, will continue to supply us with the certified copies of the constituting documents from the overseas jurisdiction. And for the nonprofit companies, nonprofit overseas companies, so we do get a lot of churches who are registered in other jurisdictions coming to Jamaica to register a branch here. And so those would, of course, be our nonprofit overseas companies. They will file the Form 31B. they will file the Form B, and of course, the certified copies of the constituting documents for the company. Please note that the BO form has a fee, so the cost for overseas companies, $25,000 is now going to be $28,000. And I didn't mention before, for the local companies, we usually pay $24,500. You're now going to pay $27,500. Let's look now at the annual return package. So our annual returns, we know for companies with shares, we file a Form 19A, and so that document is no longer going to come alone. So it is now going to come with the BO Form A. So the two documents will become the package. The Form 19A, $5,000 is for that document, and our Form A, BO Form A, $3,000. There is a late fee attached to the filing of the BO Form A when it comes annually. It has the same 28-day grace period as does an annual return. So the same 28 days grace period follows for both types of documents. So there is an obligation now to file this BO form, and it attracts a fee, and it also has a component where it can be late. Please note that the annual return section 121 $100 a day penalty has been removed with the amendments. You are no longer required to, you're no longer having that penalty. There is no no $10,000 penalty. You only will be having a late fee with annual returns. And we implemented that change on the 24th of April, which was Monday. So no longer is the section 121 penalty applicable for annual returns, okay? Only late fees. So for the annual return, when it is late, it is $5,000 for the return, $2,000 if it is late, okay? And for the BO form, it is to come in, it's $3,000. And if it is more than 28 days late, then a late fee will apply to it. For nonprofit companies, the BO Form B must come in with a 19B. And of course, we know that there is an annual obligation for companies limited by guarantee to file an income and expenditure statement annually. Now, of course, we have instances where companies limited by shares are to file financials. That continues to be, that has not changed. But because it is not all of them, I didn't make that notation. So just a reminder that that obligation has not changed. As it relates to our overseas companies, there is no new dimension to the annual filing. Of course, whether the overseas company is one with shares or without shares, it must file a financial statement. Now, the overseas companies will be filing the BO Form A annually, and for the overseas companies without shares, they will be filing the BO Form B annually. So there is now two documents that must come in annually for overseas companies. They will be filing a financial statement as you normally do, but you will also now be filing the BO Form A and B. Return of allotments. And so this is the third instance within which the BO form will be required. So we're accustomed to filing a return of allotment, one form, all is well. Now going forward, you will have to file the BO Form A. And of course, the late fees that are associated with the return of allotment is late after 1 month. That is a provision in Section 52 of the Companies Act. And so the same late fee applies to the BO form in that it has a timeline within which it must come in. And so where the return of allotment is late, the BO form will be late. And so you now have a package with the Form 9 and the BO Form A. Now, you will also note that overseas companies are now required to file a Form 9 when there are any changes with shares. This is totally new. Usually, once an overseas company is registered, apart from filing their financials, they would have notified the registrar of any changes on a Form 5. However, the requirement is now that the notification come on a Form 9 under Section 52 that has been amended. And so the BO Form A would come in for the overseas company. And of course, because of the provisions as it relates to overseas companies and changes, the documents from the overseas jurisdiction must be provided and certified either by a notary or by the officers of the company. So those are the requirements as it relates to new allotment of shares. And the final, well, not the final, the second to last, there's one more instance within which you will give us this BO form. So changes. So you are accustomed to filing with us Form 23s, Form 20s. Now you will be filing changes in shareholders and beneficial ownership information. And that will be coming to us on the Form 27A and the Form 27B. And of course, 27AB for companies with shares, and 27B will be for companies that are without shares, or loosely called non-profits, but are guarantee companies without a share capital. And so for the change form, C for change, the BO form C will come with the Form 27A, and the BO form C will come with our non-profit companies with the Form 27B. Now this package is for $6,000. The Form C is for $3,000, and the 27A is for $3,000. And you may be wondering, why do I need to file both forms? The Form 27A represents the public information, which is a change in shareholders, and the BO Form C will represent the private information for the changes to the beneficial owners. Now, nonprofit companies, obviously, they do not have changes in shareholders. However, they do have to notify us when the BO changes. So that information will start from the 27B and flow to the private information on the Form C. There is the same requirement as with all our change documents. We've tried to keep things consistent as it relates to that 14-day within which to notify us of the change. And so that requirement for notification of the change is also 14 days for the Form 27A and B. And just similarly, if there are numerous changes occurring within that time, they can be noted on the forms once they are within that 14-day period. And the final form that we will look at, and the final package, is our change in ID package. Or Form 5A is the same form that we will use for companies with shares and for companies without shares. However, you will have to provide us with the actual IDs. Certified copies of the IDs must come in. So where, for instance, I registered the company on May 15th, and my ID is going to expire, let's say, on June 20th, I will have to file a Form 5A notifying the registrar when I get my new ID, and of course, provide a copy of the ID. And so, thank you. Sorry about that. Right, so you will have to notify us when the ID changes, provide us with a certified copy. There are numerous persons who can certify the copy of the ID. So it's not just a justice of the peace, an attorney can do it, a consular general can do it, notary public. There are a wide range of persons, and they are indicated on the Form 5A who are all the persons who can certify the IDs. And of course, if you do have the original ID and you are in the company's office, we are also able to accept it, having indicated that we've seen the original. So we're going to look now at some document acceptance rules. What's going to happen going forward. So for new company customers who are filing new companies being incorporated must use the new form and the new and updated form. All resubmissions must be done that are on the old forms. So if you have a rejected new company, you can resubmit it on the old form. And you don't have to give us the new beneficial owner form. So only if you're filing for the very first time that we will expect the new form and the new BO form. But if you have a rejected company here at the company's office and you have not yet resubmitted it, we will take it on the old form. Same for the annual returns. If you're filing an annual return for the first time, we are expecting it to come on the new form and the new BO form. We will take all resubmissions on the old form. Okay. Now, what is important is that on the 1st of May, which is afternoon, which is Monday morning coming, we will start issuing new forms, in that if you go to the cashier, the new forms will be the only form that is available to purchase. Similarly, if you go to our website, you will not be able to find the old forms. However, we have given you a small window of grace, so we will allow old forms with new submissions. So for instance, a lot of you may have clients who are just bringing in forms that you would have given them months, weeks, or days ago, and they have brought them in now with the signatures, and you are like, I cannot do these over. I just got these. So we will be accepting the old forms for new submissions up to. So you have a 2-week window. So you have up until May 14th, because on May 15th, we'll stop taking the old forms. So if you have completed forms already prepared, we will be accepting them. We will not ask you for the BO information. So if you have a new company form to file with us and it's on the old form, we bring it. It doesn't matter, we will take it and we will not ask for the BO forms. If you have resubmissions, we will take the resubmissions and we will take those up to 31st of March next year. So any rejections that have not yet been registered, and you may have, for instance, some cases that have been languishing and you're waiting on some with assistance from us, or you're waiting on something from one of your clients and it still has not yet been resolved, you have up until March next year to resubmit on the old form without giving us the BO information. All right, and just to point out as it relates to the use of the status quo, because some of you do use the status quo forms. Now, if you have a company that has been using the status quo form, you cannot continue. You must file a new annual return with the beneficial owner form, provide us with all the IDs. When that annual return is registered, then you can proceed using the status quo once you have established, of course, that there are no changes. So that is allowed. And we do have a status quo for companies limited by guarantee. So that provision exists, but it is the same rule. If you were using the status quo, you will now need to file a new annual return and the beneficial ownership return. And having gotten those documents approved, you can then continue, as long as there are no changes, to file the status quo. 1 minute, I'm just gonna turn my door. 1 minute. My apologies for that. It relates to change documents. All companies must file changes as long as there are changes in the beneficial owner on the Form 27A and the Form 27B with the Form BO Form C attached. Now, there is an exemption as it relates to public companies and nonprofit companies. So public companies will not be allowed or will not be required to file changes in shareholders. So as you know, the shareholders of public companies will range from 1 to 1 million. And we are not expecting to be notified of those changes because for public companies, those changes occur by the second, by the minute. And so you will not be required to file a change in shareholders. You will be required to file a change in members. Sorry, not members, beneficial owners, my apologies. So the beneficial owner of the public company, you will notify us of the change. And right now, for instance, for public companies, we are seeing persons indicating that the board of directors are the beneficial owners. So it would mean, for instance, if the board changes annually, then it means that you will be filing a Form 27A indicating that these persons are no longer the beneficial owners and this new board, these people are the beneficial owners if those are the persons so deemed to be the beneficial owners of the company. So the exemption is companies that are public companies. We will not be accepting the changes in shareholders. You're exempt from filing that. You are not exempt, of course. You must file beneficial owners. So you're exempt from giving us shareholder information, the changes in the shareholders, but you must provide changes in beneficial owners. Similarly, for companies limited by guarantee, we want to say, or non-profit companies, we do not expect, and it is not an obligation to file change in membership. The same principle applies to Nonprofit companies and membership, the membership can range from 1 to 1 million. And so we are not going to detain persons with giving us that information. We will not be able to process that volume of information. So nonprofit companies are exempt from giving us changes in membership, but you must give us changes in beneficial owners. And what that will look like for a nonprofit in the case of a church, if it is that the pastor who might have been named as a beneficial owner of the church retires and there is now a new pastor, and that person is deemed to be the beneficial owner, then we would be expecting that Pastor Brown has ceased to be a beneficial owner and Pastor Green is the new beneficial owner. So that is what that would translate into in terms of notifying us of a change in beneficial owner for a guarantee company. As it relates to our return of allotment, the same principle applies. We will accept new forms for new return of allotments, of course, with the beneficial owner form. However, up to May 15th. So on May 15th, we will not be taking the new forms. Oh, sorry, the old forms. For resubmissions, the same principle applies. We will allow the resubmissions up to March next year. So again, I just want to clarify, we will start issuing the new forms on May 1. So that means if you go to the cashier, if you go online to our website, you will only find the new forms. However, if you have completed new forms, you have a grace, you have a 2-week grace period within which we will still be taking the old forms. So we will take old forms up to the 14th of May. So come the 15th of May, we will stop taking the old forms. But as it relates to resubmissions, you have a long period to deal with all resubmissions. You have up until March 31st next year. Finally, under the document acceptance rules is, of course, this issue of identification documents. These are to be provided at incorporation. They are to be provided annually. They are to be provided when you are filing the return of allotment and when you are doing the changes in membership and beneficial owners. So you will be giving us, apart from additional information on the form, you're going to be giving us a lot of identification documents. Now, I know we are running out of time. There is 8 minutes left. It is my intention to go very quickly through with you to expose you to the BO Form A. So I am going to just very quickly carry you through the BO Form A. And I do appreciate it is not to rush through with you. It is just to show you what it is about. We will have a forms training where we go through all of the 6 forms in detail. And so this is page 1 of the BO Form A. And I'm showing you this form because it will come in with most of the majority of the documents that are filed at the company's office. It will come with the Form 1A. It will come with the Form 31A. It will come with the Form 19A. And it will come with the Form 9. And it will come with the annual submission for overseas companies. So there are at least 6 possibilities at which you will be using this document. And so in the usual fashion of our forms, you have to indicate the name of the company, put the company registration number, of course, where applicable. If it is being used with a new company, of course, there will be no registration number. For where it is being used with an overseas company, such as a Form 31A or with the annual submission as it relates to an overseas company, you must indicate the country of incorporation and the principal place of business for the overseas company. Now, the most critical thing on this first page of the Form A is that it has 2 date sections. So at 2A, this is a section for the made-up date for annual submissions. And so this section is left blank for new companies. You do not fill out part 2A. So to fill out 2A is when you're filing with an annual return or your annual submission for your overseas companies. And what we are expecting as it relates to the date is a similar made-up date that you would have for your annual return. So we've indicated like the annual return period you would put there, or the period at which you would have filed your financial statement. And so, for instance, persons would be putting for their 2023 return when it's due. If it was due the 31st of December 2022 would be the start date, and the end date would be the 31st of December 2023. So that is the same principle that is going to be applied as it relates to the made up date at item 2A. Now, if you're filing the Form A with an incorporation, so you're bringing it in with your articles, your Form 1A, the date at item 2B is going to be the date on the BRF. So of course, the two mandatory forms that you're accustomed to filing, the 1A and the BRF, you're now filing the Form A, and the date on the BRF, which is usually the latest date or the oldest date on the two forms, is now going to be the date you're placing here on the Form A when you're using a new company and filling out item 2B. When you're using it for a return of allotment, it will be the date at the end of the return of allotment period. When persons are filing their return of allotment, what we find is that persons either put the date start to end, or they will just put the end date. And so it is the end date that you will use when this form is coming in with the return of allotment. We move to page 2, and page 2 of the Form A is very similar to what you would have been seeing on the 19A and the 1A, where you indicate the name of the beneficial owner, and then the name, the address, the nationality, and the occupation of the beneficial owner. And then you must then indicate, how is this person the beneficial owner? You're looking at the relationship the person has to the company. Is it that the person has 25% or more of the shares, 51% or more of the shares? Is the person having ultimate control of the company or control of management of the company? And of course, so this section is very similar to what we have on our or had on our annual return. And in earlier trainings, we would have explained about the cascade test, where when one is trying to identify the beneficial owner, you go through whether it is through ownership, whether it is through control, whether it is through management. But the new requirements say you must identify, there has to be one. And so you are now able to select which of these criteria apply to the identification of the beneficial owner that has been listed. So you would also see, of course, that remember, this form is private and confidential, so it doesn't have a file by page. Information that would have appeared on the file by page is now a part of the form. So the date the person commenced to be a beneficial owner, their taxpayer registration number, their date, and their date of birth. So for the date of commencement to be a beneficial owner, one will use the day that the persons are subscribing to the articles. So for the Form 1A, persons are subscribing for shares, and this is the date that the beneficial owner would have commenced. Where the form is being used annually, it will either be the date of incorporation or the date that the shares were being allocated, as in with a Form 9, or if there is a transfer, if you're using it with an annual return, the date of transfer. This is page 3, and this is where you have a corporate shareholder or corporate member. And in similar fashion as we have on our existing forms that we've had to strip away, this information would not be new in terms of how it is presented. So you put the name of the corporate shareholder. So it would be, let's say, Happy Life Limited. And then we will list who is the beneficial owner of this corporate shareholder. And we'd have the name John Brown, 1 River Road, date of commencement of the corporate shareholder, and utilizing the same information previously. The date, if it's used with a 1A, the date of subscription of the shares. If it is used with a return of allotment, the date of allotment. And if it is being used with an annual return, you'd either have the date of incorporation, or you would have, for instance, the day shares were allotted or the day shares were transferred. Also, of course, you have to note, how is this person the beneficial owner? And you cycle through whether it's through ownership, whether it's through control, or whether it's through the management of the company. This page is where you have to notify us of the changes in the shareholdings of the beneficial owner during the period. And this section is going to be left blank for the new companies because there is no period. It is a new company, it's a newly intended company. And so it is the same information that we have on our annual returns. This just relates to the beneficial owner. And so you would be very familiar with filling this out. We've had this format since 2018. And so you would just be using it the same way, putting in the name of the beneficial owner, how many shares they had at the beginning of the period, were there any changes during the period, you'd indicate the date of the transaction, what type of transaction it was, and then you'd also be indicating the date the person commenced as a beneficial owner, their TRN, and their date of birth. And the last page of the Form A, is where we are speaking about the beneficial owners who cease to be so during the reporting period. This section is left blank for new companies, and the members who cease to be so during the period left blank for new companies would only be completed annually or when there is a return of allotment. And of course, with all our forms, there is a declaration section that it can be signed by the director, the secretary, authorized official, or the member. And so this is a quick snapshot of the Form A. As I said, I've introduced it because it's going to come with almost 90% of the documents that are filed with us. And for you to just have a glimpse at what are expectations, this presentation will be available on the BO Hub Jamaica that I had shown you earlier. So, and of course, we will be having 2 other sessions to go into detail with the other forms. As I said, there are 6 forms, and we know that 20 minutes, 10 minutes is certainly not enough for you to digest the material here. So this brings us to the end of the content for today's session. And so I will ask that if you have any questions, you can either type in the chat or you may unmute and ask. So the first question I'm seeing is the removal of the late penalty retroactive? And yes, so it means if your company is delinquent, if you have not filed, for instance, if you haven't filed 2018 up to 2022, you will no longer be charged the penalty. So you will only owe us $7,000 for each annual return that's late. Let me just read one more question here before I take the raised hand. The BOR asks for TRN of the BO. What if the person is not a Jamaican? The persons will be accepted. So the passport will be accepted. The driver's license will be accepted. If the person has neither, no, we will not be taking any person's social security number. We do understand that persons, the risk with social security number. Somebody, you are saying that the person has no identification at all, then it would stand to reason they will not be able to be registered on the company because they have to be identified. So Amanda would have led the presentation explaining to you that the Financial Action Task Force has applied various sanctions to the country, and the country must comply with certain standards. And so the identification of all persons in the company is not a mandatory requirement. So it means that a driver's license, a passport, or whatever document identifies the person in their homeland that is used, then that has to be provided. So no, we wouldn't be taking the social security. So hold on a minute. I'm going to take Ms. Facey, your hand has been up. You can go ahead and ask your question, please.
Thank you. Thank you for the presentation. Very comprehensive. So is there a transition period that is going to be allowed for companies to come into compliance with this? That's one. Secondly, the law provides that the penalty for not filing the annual return on time is up to $5 million. Is it that has been changed? Is that no longer in the law? Thirdly, who is in, what is an implied trust? I wasn't sure what is an implied trust. And who is a nominee shareholder and a nominee director? I know it's a lot of questions and I actually have more, sorry.
Okay, well, I'm going to take them one by one. I'm hoping that Mr. Ferran is also making note of them. And so you asked if there is a transition period. So no, there is not a transition period. The act came into force and we have been charged with ensuring that it is implemented as soon as possible. So there is no transition period. However, we are appreciative that the changes with this Amendment Act are quite far-reaching, are quite a lot. And so our intention as it relates to compliance of all of the things, all of these new powers that the registrar has been given, is to work with our customers, work with you. It is not about just going after the sanctions that are there. So our intention is to partner with you and to work through the new role of the registrar, and of course, guiding you through how to comply with the obligations now set out in the Act. So unfortunately, there is no transition period at this time as it relates to the penalty of $5 million. So what it is, just to explain, is that at Section 121, the annual returns before the Amendment Act, the penalty that was there was that if you had not filed your annual return, then $100 a day penalty would have been due, and it was capped at $10,000, and that was payable to the registrar. Now that whole section has been removed, it has been amended, and it has turned the failure to file an annual return into an offense. And so when you commit the offense of not filing your annual return, you're liable on summary conviction, a fine up to $5 million. So that is still there. That is the new sanction that relates to failure to file an annual return. And so it means that the Companies Office, where you have failed to file your annual return, the Companies Office can pursue you through the courts, through the parish courts, to obtain whatever the judge would award based on what is contained in the Act. So that is the new sanction related to the annual return. What has been removed is that Section 121 $100 a day penalty. And so all we are collecting, if you are late, is the late fee. I'm going to read, so Ms. Facey, no, you had two more questions. So you asked about the implied trust. What is an implied trust? I don't think and you asked about nominee shareholders and directors. So I'm going to skip over the implied trust for now and just address your question as it relates to nominee shareholders and directors. So the definition, as you would appreciate, is not in the Amendment Act. And so the term nominee shareholder and director have their usual meaning. So there is no special meaning to them. They were not included in the Amendment Act. And I do imagine you're asking yourself, and I'm sure many others here, the fact that they are prohibited, why wasn't it described or defined? And so they have their natural meaning as they do in company law. So that is really the answer to that question. As it relates to nominee, the implied trust, could you just ask that question again, please, so that I make sure I get what was the question?
Right, I can't recall the section, but there was a section where it refers to an implied trust. That notice must be given, I think it is. And I'm not sure, I think Shelley just put up a response there about implied trust.
She did, yes.
By operation, yes. By operation of law.
Okay, right. So Ms. Leon has responded. Okay, all right. So
I'm not sure I fully understand, but I won't detain you.
Right, so I was going to say, Ms. Facey, what we will be doing is that we will be going through the questions that are typed in the chat as well as those offered up verbally and trying to answer them and post them on the BO Hub. And we also will take note of who was asked and we reach out to you with a comprehensive answer. So your question as it relates to, I think the nominee shareholders and the implied trust, we will respond to you officially and also post the answer on our website, the BO Hub, so that other persons can benefit from the response. So I know you said you had many other questions, but I'm just going to ask you to just let me go through the chat, and I see another person with their hand up. So allow me to just go through the chat, and I'll take Ms. Pinnock, and then if there's no one else, I'll come back to you. So I haven't forgotten that you had other questions. So just give me a minute. Let me see. All right, so, okay, so that was a question about the retroactive. And then Andrea asked about the absence of identification. It was indicated after the first year using the form, change, and it can be used. All right, so the question as it relates to the status quo. So it's indicated that after the first year of using the form, the new form, if there are no changes, then the status quo can be used. Is it that the BO form is required to be filed with the status quo? No, the status quo has a notation that no change has been made to the beneficial ownership information, and as such, none is required with the status quo. So just for clarity, you would have to have filed the beneficial ownership information with a brand new annual return, provided us with all the IDs, and you would be saying in the new year, let's say 2024, that there is no change, the IDs have not expired, the beneficial owners are the same, everything is the same. And so that would be the occasion that the status quo will arise. If, however, there has been a change, you will have to file a regular annual return, as is the practice now. And let me, so Ms. Pinnock, I haven't forgotten you. We're submitting updated IDs.
Oh, you're okay. Close the morning.
All right. So as it relates to identification submissions, it is for the shareholders, the members, and the beneficial owners only. And yes, please pardon us. We are behind in making the forms fillable, but the forms will be fillable within the next couple of days. So just bear with us. We do know that we have put up the forms and they are not fillable. So that will happen. And so the next question is, where in the Companies Amendment Act speaks the requirement for 2 directors and a director? So to sign notice to the registrar of financial, for 2 directors or a director and company secretary to sign notice to the registrar or financial returns. So this question is in relation to regular filing of financial returns or notice to the registrar for overseas companies. So for the overseas companies, in the 2017 amendments to the Companies Act, there is a requirement for certification by the directors of the company or a notary. But if you're relating to the attestation that we ask for, that the financial statement is certified to be a true copy, I'm not sure. So I'm gonna ask Althea if she can just maybe explain some more. All right, so there is a question from Ms. Buddington. Is a national ID accepted? Yes, a national ID is accepted from an overseas person. Yes, the obligation to notify us of changes in ID. Once the ID expires, yes, there is an obligation to notify us of the change. You say as soon as they expire, that is the thought process, that is the hope that you will notify us as soon as they expire. There is also an obligation of the registrar to write to persons whose IDs have expired. And so, yes, we do hope that where the IDs expire, you will reach out to us. I'm going to go to Ms. Pinnock. I think Ms. Anderson has another question, so I'm going to go to Ms. Pinnock. Ms. Pinnock, you can ask your question now.
Okay, thank you, and good evening, and thank you for your presentation. To the extent that the Amendment Act does not speak to nominee shareholders and directors, working with a company that comes under that establishment, how do we proceed in filing our annual returns, which are due shortly?
All right, I'm going to ask Ms. Leon if you want to take that question.
So are you asking, all right, so are you asking if according to what is held out normally to by a nominee director or nominee shareholder, if you have a client and that client has someone who would be deemed as a nominee, what you would represent on the annual return? Is that what is being asked?
Not quite. How our company is structured, that it has one nominee shareholder, but it's because it comes under an international company. But I'm wondering that because the Amendment Act does not have a definition for nominee shareholders and directors, do we continue to file our annual returns in a regular way? Or is there something else that we do?
All right, so this company that holds the share, they are nominee for a natural person or a legal person?
Right.
All right, so in that case, if they are nominee for a natural or legal person, then that would have been prohibited by these amendments which have come into effect. So what we have been doing for persons who indicate that there are those situations that are in place, we've been having further discussions with them to see what we should recommend or advance as a policy change. But as at this moment, the annual return forms that exist would not have any provision for nominee shareholders. So what we will have to do, so perhaps outside of this forum, we'll probably have to have a Zoom call or so on, or if you want to send something in writing regarding the particular structure so that we can look at it and maybe see if there can be any particular workarounds at this time.
Well, Ms. Leon, we have sent a letter to your offices, so we're just awaiting your reply, and then I guess we can take steps after that. I mean, if your suggestion is to have a meeting, then we're amenable to that.
All right,
so we're just
I'm
officially waiting on a response.
Right, I'm not aware of that correspondence. That correspondence has not come to my attention as yet. So,
okay.
Well, Ms. Pinnock, what you could do, you can send us a message directly without the other participants. You could maybe just send us your contact number, send us a direct message so that we could reach out to you so that we can just clarify which company it is, because you know, we do get a lot of letters. So if you could just send that a direct message to us now in the chat so that we could just make note of which entities it is and that we can reach out to you.
Okay, will do. And thank you for your responses.
All right, so thank you, Ms. Pinnock, for those questions. So there are other questions in the chat, so I'm going to go through those. And of course, Ms. Leon, thank you for your response. So there was a clarification of the IDs if they expired, and yes, you must, we wish those to come in. All right, so the next question from Althea is, when a company is incorporated in the past, COJ would provide an overleave for the duties of the company, for example, filing returns, which such overleave.
Mrs. Bennett,
yes.
sorry to cut you. I would have gone through those already and
you did answer? Oh, perfect.
Yeah, so I think the last one that is there would be connected to the last question that was asked regarding the nominee arrangements, and it was a comment from Oral Gillespie. Sorry if I missed it. Yeah, if I haven't pronounced that right. Wouldn't that person as the nominee be holding shares for someone? So the beneficial owner of those shares is what the old annual return displayed. So he was just commenting on Ms. Leon's response to the question posed regarding nominee shareholders, nominee arrangements.
Okay. Okay, excellent. And well, just to clarify for everybody, yes, we do have our packages. When persons are incorporate, we do have, the package has been updated, the website has been updated. So once you incorporate, you will get the package with the new requirements of what next. And of course, or what next outlines the annual returns. It now includes the beneficial owner return. It, of course, will tell you what to do when there are changes in terms of directors and shareholders. And of course, it now includes the Form 27A and B.
To indicate though, Inga, in regard to that comment that would have been made by Oral, so even though this had been done previously, the issue is when you identify how you are a beneficial owner, that is going to be a problem, which is why I have indicated that we have to respond.
30 in the morning.
All right, take care.
You're coming in?
Yes, yes, I'll be here. Okay.
Yeah. All right. Althea is do you have a new question, Althea?
Good evening, everyone, and thank you. Just for clarification, as it the first question regarding the filing of notice to the registrar. So in this particular case, I would have received a requisition that any amendment pursuant to the requisition needs to be signed by a director and a company sec or two directors. So my question is, can it be signed currently by a director and an officer authorized to sign? So in other words, until we get it to May 15, can that be accommodated?
Right. So you have a rejected document asking for 2 signatures, and you're saying, okay, May 15th is upon us. So so we are allowing you, once it is a resubmission, Althea, you have up until next year, March, to give us that document. Not suggesting that you want to keep it that long, but we are taking the old forms up to next year, March. Now, the question, of course, relates to the persons to sign. So we would have been asking for 2 officers of the company. You're saying you only have 1 officer of the company available. And this is for a financial statement, or this is for the certificates on the annual return?
So there are 2 pending things. One has not been submitted as yet. As it relates to the notice to the registrar, it's signed by a director and by 1 director, I'm sorry. And as it relates to the financials, it is signed by a director and an authorized officer. So we're speaking about 2 different things. So we're speaking about a Form 5 notice to the registrar, and this is in relation to 1 entity. Another entity is separate, filing financials, overseas entity, filing financials, but it is signed by a director and an authorized official. Go ahead.
No, so the notice to the registrar can be signed by 1 director. So that's a local company, right? For that instance, that's a local company, right?
Yes, yes.
Right. So that's a local company notifying us of something on a Form 5. Yes, 1 director can sign that, as long as they're duly appointed. Then the other instance is the financial statement. You're saying this is for an overseas company?
Correct.
Right, so, and these are audited financials.
Audited financials, yes.
Right, and so there would be something in the document that evidences that they're audited financials, right?
Indeed.
Right. So one director can sign. You say we rejected it, saying 2 directors are to
No,
sign?
it hasn't been submitted yet. I'm just making sure
Okay.
since I would have already given
Okay.
approval that COJ would accept it. So I'm just making
Yes.
sure.
Oh, no, no, I understand. No, you know, one director can sign is their audited financials. There is a page, usually there's a page within the financials that the auditor has indicated such. And then on I think the front face, we ask for certified to be a true copy by one director. That is fine.
Okay, thank you very much. And my last question, which I believe many of my colleagues may be wondering as well, what is the impact, if any, or implication, if any, between the COJ and FSC as it relates to the license? I'm not sure if you are planning on having another discussion regarding said.
All right, so yes, we were asked this question this morning, and Ms. Leon, you want to take the answer?
Thank you so much.
You're welcome.
So the Trust and Corporate Service Providers Act does not designate the COJ with any kind of enforcement role. The FSC, they have been issuing bulletins on their website. And so persons would have to be guided by that. The FSC as a regulator may from time to time approach the COJ to verify certain information or to ask certain information which can assist with their role. But at this point in time, the COJ would not be asking service providers to provide proof of registration as a licensed PCSP.
Okay. Thank you, Ms. Leon. And Ms. Facey, you said you had other questions.
But I'm aware how late it is, so I will refrain.
Right, and we do thank you for your patience. We do appreciate the questions, and yes, we appreciate that it is late in the evening.
Ms. Bennett, may I ask one last question quickly?
Yes,
you would have presented on this, but I think I may have missed it.
As
it relates to the filing of the financials for an overseas entity, did you say it has to be accompanied by the beneficial owners as well?
Right, so going forward, yes, the Form A for the companies with shares, they would now have to file a beneficial owner return annually. So
okay, and if it is submitted before May 15th, then you'd accept?
Yes, without,
okay.
Yes.
Okay, thank you so much.
We do appreciate it is very late in the afternoon. We do appreciate your questions. We do know it has been quite a lot of information. We are sure that you will attend the other 2 sessions that we will have. One where we will go through the forms in detail with you, and the other where we go through the powers of the registrar, the obligations for companies and the registrar, and the sanctions that now exist in the Amendment Act. And of course, that is of course very relevant to all of us here. So I want to thank you at this time for all your questions. We're asking if there are other burning questions or other concerns that persons wish to indicate to us. We're asking if you could email us, Wayne or Amanda, if you could just put the email in the chat for persons to just email us through there. And Ms. Pinnock, I'm kindly asking if you could just type a direct message either to Ms. Wallace or myself so that we can get the numbers so that we can follow up on that letter that you have written to us.
I'm sorry, I had sent it directly to Ms. Leon.
Okay, perfect.
Okay,
excellent. Thank you very much. So thank you all for your time. Have a good evening. Oh, Wayne, well, as you sign off, this is just to show you the Beneficial Owner Hub, which is our new website for all information relating to beneficial owners. A copy of the act is on the website. You can watch the presentations that we have done, and the presentation, the physical presentation, is also available. Previous presentations and the current presentation. All the new forms are there, and there are some frequently asked questions, and that pool of questions will increase because, of course, so much information is coming from these sessions that we're having. We also have a beneficial, Kawane is showing you the various news articles. So interviews that would have been conducted on Love 101 and on Smile Jamaica with Miss Leon, you can listen to those. And of course, various newspaper articles that have been written about the area, the subject matter. And we have a beneficial owner booklet on the home page. You can just click on the information booklet. It is comprehensive. You can go through to see, you know, what's the content there. Of course, as we're saying, because there is so much information and there is the changes to the act are so far reaching, you can use this quick guide. We have pictures, diagrams to show you how to identify the beneficial owner in various scenarios, such as in trust, such as in nonprofit companies or guarantee companies, and all the sanctions. We've pulled out all the sanctions. We've highlighted them on the various sections so you can see what is there. And of course, the new Companies Act, the Amendment Act is available. So you're able to view it and download it and have your own copy. So thank you very much, everyone, for attending. We do appreciate your feedback. Again, for you to note that it is a collaborative approach as we implement the amendments, and it is a partnership where we will work together with you. And we do appreciate that the changes are far-reaching and they do have a lot of impact on the documents you file with us. So we are here to help and to serve you. So thank you very much for coming out. Have a good rest of evening. Good night.
All right, all.